Friends, today I will be discussing when to file a patent application in India or file a patent application for XYZ countries. It's basically, whether to file an international patent application under the different treaties, which will actually safeguard your intellectual property, which you generate during a course of doing business. First and foremost, you should need to understand that first step is doing your market research. As an innovator, as a creator of a business model, you should understand whether filing a patent would be beneficial for you in the long run. Seeing the scenario of India right now, it is a must for every startup in the tech sector. And when we talk about technology, technology is not only in the mobile app sector. There are many other sectors whereby you can file for patent applications, and patent is granted for a new idea per se is not patentable, but idea gives rise to innovation. So we need to understand there's a difference between idea and there's a difference between innovation. So obviously you need to pen it down and put your thoughts on paper and have a discussion with the patent attorney or the patent lawyer with whom you would like to associate, and understand whether your idea or innovation or the business model which is in place is patent worthy. So the first and the basic requisite is that the patent or the idea or the innovation should be new, novel. And when we say new and novel, it means it should not be disclosed anywhere in the world. Patent is granted for a technology which is new, and it should not be obvious to the person who is already skilled in the art. When we say a person skilled in the art, is basically a person who is an expert in that field. It should not be but obvious that just changing XYZ features in a mechanical invention, it becomes new. So it should be something, or the idea or the innovation should be new in terms of disclosure in the public domain. Basically, a patent is a contract between the government and the inventor. As an inventor, you disclose something to the government, and the government is giving you the right to protect your rights for 20 years from the date of filing. And once a patent is granted, or even when the process is pending, you can go for licensing deals with companies across the globe. You can get royalties. So there are a lot of benefits of filing a patent application. The another benefit of filing a patent application is during the investment stage, you can actually talk about the intellectual property which you have generated. And the scenario in India is changing. Now the VCs also are taking into consideration the aspect of what is the worth of the patent. Earlier, a patent grant was like, the stretch was a lot, like almost 10 to 12 years. Right now, that lack phase is a little less. It's right now somewhere between 4 to 5 years. And as things are going and moving in the right direction under the leadership of our PM, we are hopeful that this lag period can come down to 2 to 3 years, and that is definitely a good sign. And there were three things which we talked about. One is the novelty aspect, second is the non-obviousness, third is the industrial applicability. The invention should have industrial applicability, it should be useful. Inventing is one thing, but using it for the benefit of the mankind is a different aspect altogether. So we at TCIS facilitate the process of understanding what is inventive, and many times as a strategy or as a strategist, we tell the clients to file and go and file for a provisional patent application. Filing a provisional patent application gives you the edge over others because you secure a filing date. And when I say you secure a filing date, is say for example you file a patent application on 1/1/2017, your protection starts from that date. So you have 1 year timeline to file a complete patent application, or in general terms is known as non-provisional patent application, with a set of patent claims, and patent claims define the scope of the invention. So it's not what you have disclosed in the detailed description part. It is basically the patent claims, and the patent claim is a particular section in a patent document which needs to be taken care of, and it has to be drafted in a manner whereby you are able to secure your rights. So it's very, very important for you to understand what kind of patent claims are being drafted by you, or the patent attorney or the patent lawyer is drafting. So you need to sit down and see what aspects of the invention you want to cover. And if you have any questions, we would be happy to assist. We are reachable at LinkedIn. Uh, Happy patenting. Bye bye. Take care.